Hi everybody, hope you all are well. Thank you so much for tuning into Nations Behind Him. As it's Legal Awareness Week, our topic for discussion today is public interest immunity. The doctrine of public interest immunity has been the center of constitutional debate, rendering it as no stranger to political controversy. In recent years, the doctrine has been used in rather contentious cases, arising from the dismissal of Harrison Ford, the death of Blair Beach, and shootings that eventually led to the Stalker inquiry. In our show today, I have invited a few guests to shed light on the growing controversies in relation to public interest immunity by evaluating the contemporary and continuing concerns with regards to the expectation of disclosure of information to the courts by law by the governments. In addition to this, we shall also be paying particular attention to how this has evolved over the years. But before I call them in, I'd like to formally familiarize the audience here with what public interest immunity is, the cases that have had a revolutionary effect on the doctrine, and brush upon the concerns that surround the doctrine. Public interest immunity, previously known as crown privilege, is a principle of common law, in which English courts grant a court order allowing the government to refrain from disclosing evidence which would be injurious to the public interest. Traditionally, all public interest immunity claims can be categorized into two: content claims and class claims. Content claims are concerned with the situation where the document in question is sensitive on its own. Class claims are the pre-categorized documents that were previously withheld from disclosed evidence in the public interest. Keeping this in mind, the legitimacy of withholding class claims has been questioned. The candor argument has been a famous justification that is put forward by a few supporters. However, in the Scott report, Sir Richard has rejected this justification when it is the only justification presented. The landmark case of Matrix Churchill paved way for further developments in the law with regards to PII. During its trial, the precise application of public interest immunity in criminal trials was unclear, which eventually led to its collapse and gave way to controversy surrounding the use of public interest immunity certificates. This ultimately led to the infamous Scott report. The former Trade and Defense Minister, Alan Clark, claims that the decision in the Matrix Churchill case was ludicrous and highly improbable. Over time, many concerns have surfaced which have made public interest immunity the focal point of constitutional controversy. There has been a conflicted view on whether national security should take precedence over administration of justice by a court of law, as public interest immunity certificates have been liberally issued by ministers under the name of national security. Considering a full disclosure policy is adopted by the government to the court of law, does it constitute as an open, accountable, and transparent government? We shall also look into the extent to which the Freedom of Information Act is successful in practice while considering the role of public interest immunity. Concerns have also been voiced with respect to the relations between the ECHR and public interest immunity. But before I give the floor to my esteemed guests to delve into the matter, it is important to clear the fact that the doctrine of public interest immunity is also concerned with the disclosure of information to the general public, as mentioned in Article 6 and 10 of the European Conventions on Human Rights. But in this debate, we shall focus primarily on the government's relationship with the courts exclusively. As we are addressing the relationship between public interest immunity and Article 6 of the ECHR, it is imperative to mention the application and relevance of such an article in our judicial system. The convention was received into UK law when the Human Rights Act came fully into force in October 2000. Section 3 of the HRA requires that so far as it is possible to do so, primary and subordinate legislation must be read and given effect in a way which is compatible with convention rights. In this light, Article 6 of the ECHR does now apply in the United Kingdom, and the courts are bound to apply it as far as possible. So without further ado, I would like to call upon stage our guests for tonight. Mr. Nakir, Director of SHIELD. Then we have Mr. Shahiran, Managing Partner at Nelson Murdoch, and finally, Dr. Claire from Cambridge University. Thank you so much for coming here tonight. So, Mr. Nakir, the floor is all yours.
Thank you, Hira. As to answer the proposition of the day, it is imperative to deliberate over 3 points of the question. The first concern is whether and should national security take precedence over the administration of justice by the court of law in relation to the disclosure of information by government. In the case of Balfour and Foreign and Commonwealth Office, the Court of Appeal held that if an information is claimed immunity concerning national security, the fact is of itself conclusive and no interest in administration of justice can prevail against it. The cardinal reason behind such decision can be expounded by the mosaic theory, which was propounded by D.E. Posen in his journal article, as well as Lord Griffiths, where he explained that a trivial fact given by the government may be the missing piece of a jigsaw sought by the hostile intelligence agency which puts the whole nation under threat. The main problem over such judicial take is that the governments may misuse the term national security to claim immunity over each and every trivial information. Fortunately, the introduction of the test of serious harm by the then Lord Chancellor following the Scott report abolished national security class-based claims, but genuinely sensitive materials are protected under contents claim. Despite the abolishment of class-based claims, the contemporary practice in courts and recently enacted legislation, for example, Section 23, subsection 1 of the Freedom of Information Act 2000 excludes information from security and intelligence services from the harm test and public interest test, which proves the preeminence of national security over administration of justice, which is highly justified.
So, Mr. Shahiran, do you have anything to add to what Mr. Nakiran had to say?
Thank you, Ms. Sira and Mr. Nakiran, for that substantial view. However, I would like to add another point which I believe is important in ensuring a well-rounded discussion regarding the topic at hand. While the notion that the government needs to disclose any and all information to the courts may seem appealing at first, one should always be wary that the facts are rarely in black and white. These proverbial shades of gray, as one may put it, refers to the types of information being presented to the courts. Said information may be incredibly sensitive and dangerous should it leak to a potential third party. As seen in the doctrine of separation of powers, it comes as no surprise that the government may be in possession of such information. This is certainly not mere conjecture, as seen in the case of Big Brother's Watch and others and the United Kingdom. In this case, the European Court of Human Rights deemed that collecting information from the general public was indeed a violation of human rights. This was particularly prevalent under what was known at the time as the Tempora program, in which the government was collecting users' personal data through their internet optic cables. Now, putting aside the moral ambiguity of collecting people's information without their knowledge nor consent, the information that's already present is incredibly dangerous and should not be disclosed to anyone. As such, the crux of my argument lies in the fact that there exists information that is simply far too dangerous to disclose to anyone, the courts included. However, one should realize that this is not necessarily always the case. There do exist times when information should be disclosed to the courts. This is because it aligns itself with Dicey's definition of rule of law, one of which states that all men are equal before the law. All men would naturally include people in positions of authority. Therefore, they should not be exempt from disclosing information to the courts, as this would help lead to a fairness of trials. Furthermore, one could argue that one does not need to worry about information leaking from the courts, as Section 23 of the Freedom of Information Act 2000 clearly states that information that is held within court records are barred from ever being released. Furthermore, people and members of the executive need only follow proper procedure and to ensure court immunity.
Let's just assume that the government does adopt a full disclosure policy. Would that constitute as an open and transparent government?
Thank you, Mr. Shahiran. Furthermore, the second question is whether disclosure of information to a court of law a manifestation of an open government. In an article by A.W. Bradley, the learned asserted that good governance ceases if evidence are inaccessible by the judiciary on grounds of public interest immunity. Citing the then Lord Chancellor's speech in 1996, it was specified that the government should maximize disclosure and claim immunity for a very few number of documents. The reason behind such commitment was explained in Conway and Rimmer, where Lord Reid insisted that a balance between public interest and justice can only be struck by the court, and Lord Templeton in Matrix Churchill case agreed that a rubber stamp approach is not appropriate in a democratic society. Conversely, the advocates for concealment of information argues that public interest immunity is not a right but a duty of the government, as adduced by Lord Justice Bingham in Makanjolo and Commissioner of Metropolitan Police. The supporters contend that the judiciary will not be competent enough in balancing certain matters, as accepted by Lord Reid, where he mentioned that when judicial experience is incompetent to weigh, then the minister's view prevails. Moreover, Lord Scarmer's justification regarding secrecy of government substantiates the argument that disclosure of information to court of law is not a vital aspect of an open government. Taking both sides into consideration, it is indisputable that a storm of suspicion among public over their representative can be avoided if government maximize disclosure to a court, which is an independent body. The disclosure of information plays an indisputable role and an indispensable role in forming and establishing an opinion over the openness of the government.
So what ensures the transparency of the government?
Thank you once again, Mr. Nakurin, for your fascinating insight regarding the topic at hand. I would like to add another point to further fuel this discussion. As previously mentioned, there are indeed merits in ensuring the government is and always will be held accountable in disclosing information to the courts. The Freedom of Information Act 2000 is a vital tool in procuring the information from the government. This is because, as stated in the Act itself, the UK government is held as a public authority as opposed to a private one. That naturally, on paper, this would mean that the government would be required to disclose any information when requested. However, it is a much different story in practice. This is because any public authority has the ability to deny any information request that they deem to be particularly vexatious. This can be seen in the Court of Appeal case of Ransfield and Information Commissioner, in which the courts decided that a request for information may be deemed as vexatious if they believe that all circumstances have been taken into account. In other words, they would not have to oblige to the request for information if it would potentially place a burden on them, as seen in Section 14, subsection 1 of the Freedom of Information Act 2000. As such, if one were to argue that the government should be held accountable in disclosing information to the courts, are they truly bound by law to do so? This issue has been brought up rather recently. Thus, this inevitably brings up the issue regarding the effectiveness of statute. The very notion that this is still being discussed in 2019, as seen by the journal What We Don't Know by Paul Gibbons, is clearly a sign of its significance. Therefore, I believe that this is indeed an important issue regarding the matter at hand.
So, in light of what Mr. Shagiran said and what we've been discussing tonight, how does human rights come into play in all of this?
Touche, Shahiran. The third and final issue is whether disclosure of information to a court of law by the government is important to uphold Article 6 of the ECHR, the right to a fair trial. The relevance of convention rights in British judicial system was mentioned by Hira as she explained Section 3 of Human Rights Act 1998. Article 6 of ECHR was well examined in Edwards and United Kingdom, where the court held assessment of evidence in a claim for public interest immunity should be independent of government because the executives could decide in favor of themselves at the expense of justice. In the same light, D.G.T. Williams questioned the priority of secret government at the cost of injustice at courts, which brings us to the case of Roberts, where the House of Lords acknowledged the concealment of information as a threat to a right to a fair trial. Contrarily, the advocates for concealment of information rely over the case of Roe and Davis and United Kingdom as to justify their stance, as the European Court of Human Rights decided that procedure of public interest immunity is not necessarily in breach of Article 6. The supporters of such argument corroborate their contention by pressing on special advocate schemes, which was heavily criticized by Lord Steyn and Lord Bingham as contrary to the fundamental legal value. So, as to deduce the third issue, in most circumstances, it is established that the disclosure of information to court of law is fundamental to uphold the right to a fair trial. Essentially, I hold that I have explained all three critical points as to answer the proposition of the day, and my sincere gratitude for such an opportunity. Thank you.
Now that we've understood the contemporary and growing concerns related to the doctrine, our audience here, and me particularly, were more interested to know how it has evolved to come to this particular point.
To fully comprehend the evolution of public interest immunity, its history should be viewed in its entirety by three distinct phases. The first phase of public interest immunity dates back to Article 9 of the Bill of Rights, 1689, which states that Parliament proceedings should not be impeached or questioned by any court of law. This article has been proclaimed in courts in numerous earlier cases, such as Bradlaugh against Gossett, which was decided 135 years ago. This concept developed into Section 28 of the Crown Proceedings Act 1947, which states that while the Crown was still required to disclose information to the courts, efforts were taken to uphold Crown privilege, which was seen as part of the royal prerogative as affirmed in the case of Duncan against Camelot. The court held that in a claim for immunity of information, the Crown's decision on the matter was absolute, and the courts should not question it. The second phase of the evolution of public interest immunity began with the case of Conway against Rimmer, as the House of Lords decided that Section 28 of the 1947 Act was a statutory confirmation to reject the ruling in the case of Duncan against Camelot. The second phase of the evolution of public interest immunity began with the case of Conway against Rimmer, as the House of Lords decided that Section 28 of the 1947 Act was a statutory confirmation to reject the ruling in the case of Duncan against Camelot. Lord Reid stated that the final decision over the immunity of information should rest upon the court to obtain a balance between public interest and administration of justice, as mentioned earlier by Mr. Nakiran. Additionally, Lord Upjohn ingeniously differentiated content and class cases, as well as asserted that a plea for the protection of documents lies solely on the necessity for candor. A major aspect of the second phase was the transition of the term Crown privilege to public interest immunity in the case of Rogers against Home Secretary. The use of the terminology Crown privilege was heavily criticized by Lord Curzon, that such an expression was misleading. This view was also accepted by Lord Scarman in Science Research Council against NAS. Therefore, the preferred term for the contemporary is public interest immunity. While traditionally the idea of public interest immunity was restricted to an internal government affairs such as police, customs, and excise, until the Burma oil case, which further broadened the scope of public interest immunity even to the banks. Such expansion was further invigorated by the case of Air Canada against Secretary of State for Trade. Additionally, the cornerstone of modern public interest immunity arose from the Matrix-Churchill case, which eventually led to the Scott Report. In the light of the Scott Report, Chancellor made a significant statement in the House of Lords on 18 December 1996, which shaped the modern principle of public interest immunity. The Lord Chancellor mentioned that in a claim for public interest immunity, the judge is the sole authority in making the final decision by taking the facts of the case into consideration. He affirmed that the previous distinction between class and content claim was abrogated, and class claims were abolished from practice. As previously mentioned, the test of serious harm was introduced. As discussing the evolution of public interest immunity, post the Lord Chancellor's statement, I feel that it is vital to address the concerns brought by Superstone and Koppel, which claim that the new approach still practices class reasoning in all but name. To conclude Phase 2, the statement by Lord Chancellor was a keystone for the development of modern public interest immunity, although it still did not escape criticism. The third phase of the public interest immunity concerns the ongoing development of the principle which started post HRA 1998. The incorporation of HRA 1998 has created a major shift in the courts while evaluating the balance between public interest and its compatibility with the convention rights, predominantly Article 6 and Article 10 of the ECHR. As adduced by Dicey in its definition of rule of law, fundamental rights should be safeguarded by common law, and this was reinforced by the rise of the HRA 1998. The issue received national attention again post-HRA 1998 in the case of R against H, which justified the special advocate scheme as the appropriate method to strike the balance between convention rights and essential public interest. Lord Stephen describes such proceeding as a phantom hearing, when an advocate is selected by the government itself to view the closed material with an onerous condition of not meeting his client at all. Such practice shows that the legal regime maintains the fundament of public interest immunity, but in a more liberalized manner. In addition, the advent of the FOIA 2000 reduced the magnitude of public interest immunity, although it has been profoundly criticized for the wide categories of information protected against disclosure. In deduction, it can be seen that the evolution of public interest immunity is certainly incomplete, but the liberalization is evident. Presently, the evolution of public interest immunity can be discussed at length. However, due to time restraint, the light was shed on the major parts.
Thank you for such an insightful discussion. During tonight's show, we explored the lens of public interest immunity claims proving to be a balancing act between competing public interests. Open justice is a fundamental element in any legal system, where PII stands on withholding evidence in the name of public interest. Sir William Wade expresses the notion that public interest immunity is a limited exception from the rule of law. Considering this, many political theorists have argued that public interest immunity poses a threat to two of the three crucial limbs of the British Constitution: rule of law and separation of powers, as this doctrine can be abused by the governments, as this has been clearly illustrated in the case of Duncan and Cameron. Whilst this argument is inevitable, it is justified that national security takes precedence over the administration of justice, despite the fact that it has been misused in the past. The preeminence of national security over the court of law is highly justified. The contemporary evolution of the doctrine has, to an extent, reduced the intensity of the dilemma. This can be seen with the incorporation of the HRA, as the right to fair trial is still being upheld, and the judges carefully scrutinize the need while keeping the responsibility of upholding civil liberties. Thank you so much for coming to our show tonight. It was a pleasure having all of you. And for everyone else watching, thank you so much for tuning in. See you all next week. Bye.